Hi everyone, and welcome to those just joining us. We're going to let the numbers settle before we get going with the webinar proper. It's great to see you all. Yeah, and we'll get going in a few minutes. Hi everyone who's just joined us. We're still having more people join the webinar. We're going to wait for the numbers to settle before we get going. Welcome back to the TUC's webinars. We've had a little bit of break over the summer, but it's great to be back online with you all. I'm going to give it maybe another minute and a half just to let the numbers settle down a bit. It's great to see some of you saying hi and introducing yourselves in the chat panel. We always encourage that. It's great to see your name, what union you're from. If you'd like to share your workplace, please feel free to do so as well. Okay, the numbers are still climbing, but I think I'll start the introductions so that more people will come while I'm doing that. So hi everybody, welcome to today's webinar. As I said, welcome back. We've had a bit of a break over the summer, but it's great to be back doing our first webinar of the autumn term in 2024. I'll introduce our speaker in a second. It's Phil Liptrot from Thompsons Solicitors, and we're delighted he's here with us today. There's lots of you joining us, which is great to see. Please do introduce yourselves in the chat panel. Tell us your union, your workplace, if you are able to. And if you'd like to share any tips or suggestions that come up during the webinar, that's great to hear also. We are taking questions. If you'd like to post a question to Phil, you can do so in the Q&A panel. So that's below the video at the bottom of the screen. It says Q&A. It looks like two speech bubbles. I'll try to get to some of those, to as many of those questions as we can a bit later. If you'd like to watch the webinar with live captions, there's a button underneath the videos that says show captions. Just tap that and you'll be able to see the captions as we're speaking. As ever, we're recording this, so if you miss something or you've got to leave early, please don't worry. We'll send everyone a link to the recording first thing tomorrow morning, along with any resources that we talk about. Okay, so over to the subject of today. As I said, we've got Phil Liptrot from Thompsons Solicitors, and he's going to be talking to us about personal injury in the workplace, and crucially, what the health and safety reps' role is in that, in navigating the process and how they can best support members in this, in both making a claim and a preventative approach to stop these accidents happening in the first place. So Phil, first of all, can you just introduce yourself? And while you're doing that, you can share your presentation, if like multitasking, and then we'll get going with the presentation. So over to you.
Thank you very much, Anna. Let me just share this. Everyone see that?
All good.
Brilliant. Yeah, as Anna said, my name's Phil Liptrot. I'm head of personal injury at Thompsons Solicitors and have worked for Thompsons frighteningly since 1996 when I did my training contract in Stoke, and I'm delighted to have been invited to speak to you all today to give a bit of background as to how a personal injury claim works, because I think it is important and puts into context some of the work that you do, particularly in helping us win these cases for your members if they are injured. And also, as Anna said, to look a little bit about how to prevent accidents in the first place. So this is what we're going to talk about today. There's sort of 7 main topics, and I'm going to whiz through some of these because we've got about 35 minutes to go through these topics. So we're going to look at the types of personal injury cases and a little bit about the law and the process, as I've mentioned, the evidence that we need to win cases and get compensation, and then, as Anna says, look at how we can prevent the injuries of tomorrow, but also help people who have been injured. And ultimately, hopefully the message will be that if we work together, then that increases the chances of an injured member obtaining compensation. And I think just before I start, I think it's probably appropriate just to mention the Grenfell disaster following publication of the report yesterday. Thompsons represented the Fire Brigades Union at the inquiry, and certainly, the report shows that 72 people paid the ultimate price of criminally substandard health and safety practices, and certainly Thompsons, the TUC, and the FBU and all unions look forward to the government and organisations being held accountable sooner rather than later. So just moving on, as I said, the types of personal injury cases can be divided really into two. There's accidents, which can involve a number of circumstances. So manual handling, typically lifting in factories, warehouses, for example, but also in care environments and hospital environments where still people are expected to lift patients despite it being 2024. Slipping and tripping, accidents at work where surfaces might be uneven, working at height, which speaks for itself, but can involve significant heights or just simply 3 or 4 steps up a step ladder. And again, despite it being 2024, we still see in non-unionized workplaces accidents relating to dangerous machinery, and some people have to work in almost Victorian like conditions despite being in the 21st century. And one of the examples that I will refer to show the grim realities of what can happen involved unsafe machinery. And I mentioned road traffic accidents because whilst clearly some of those accidents can happen during the course of someone's employment, if you are a driver, particularly with the increase in the gig economy, for example, it's also relevant if someone has an accident, a road traffic accident outside of work, I think, in your role, and I will come on to that later. So whilst I'm going to focus on accident cases in the process of bringing a personal injury claim, we clearly do also run disease cases, and asbestos being a significant proportion of them, despite many people thinking that the number of asbestos-related diseases would have peaked maybe 20 years ago. That hasn't, unfortunately, tragically been the case. It's just a different type of worker now who is contracting these diseases, such as teachers or canteen assistants, for example, in schools, partly due to the Tories' austerity measures from 2010 onwards, putting a halt to the school refurbishment programme, but also cases where someone has been exposed to chemicals and developed, say, asthma or dermatitis, vibration-related conditions, hand-arm vibration syndromes, vibration white finger, and also diseases caused by repetitive tasks. Noise-induced hearing loss, less so now, but we still do see people whose hearing has been affected by um, by um, uh, industries where the noise levels are unacceptable, and an increasing number of people who suffer from stress at work, either through overwork or bullying and harassment, for example. I mean, we could probably do several webinars in their own right dealing with most of these issues, but as I say, I'm going to focus on the accident cases in relation to the process. The good news, as I say, to start with, is that if you are a union member, then you will receive 100% of your compensation if you're unfortunate enough to be injured and you bring a successful claim. Then 10, 15 years ago, the government allowed lawyers to take up to 25% of an injured person's compensation. But as I say, the trade unions don't hold any truck with that. And as a union member, you will receive 100% of your compensation. So it's one of a multitude of reasons why people should join a union. So to start with, really, I just want to there's two bits of law that I want to go through. Firstly, the time limits, which is really important as a health and safety rep to be aware of. I mean, the rule of thumb, I suppose, is that if someone does have an accident or develop a disease, then the sooner they get legal advice, the better, and the more likely it is that they will obtain compensation for fairly obvious reasons. Evidence is fresher. There's more time for a defendant to take a view, an employer to take a view and settle a claim. But we do need to be aware of the cut-off point. So for an accident, then it's reasonably straightforward. It's 3 years from the date of the accident. We have to issue court proceedings. There are some exceptions, as you can see there. So if an accident happens abroad, then various countries have different limitation periods. If it's at sea, then that differs as well. For a disease, it's slightly different. It's still 3 years, but it's from 3 years from the date the person realised or should have realised the disease condition was work related. An example being that, say for example, with some hearing loss, they've noticed the hearing get worse over, say, 5-6 years ago, but it's only when they go on the TUC website and look at hearing loss claims that they think, I think that's to do with my work, and they then come to see a lawyer, and potentially they are still in time. The problem perhaps might be that if their then GP records show that they'd gone to their GP 4 years ago with reference to it being noisy at work, then a court is likely to find that they should have realised that that was work related at that time. If you're assaulted at work or indeed outside of work, then there's 2 years to put in an application for a criminal injuries compensation authority award. You can do both. You can put in an application and you can bring a personal injury claim. It's just that you have to take into account any awards that you might get from your personal injury claim in relation to the CICA award if one is made. Children, it's slightly different. 3 years start from their 18th birthday. Similarly, if someone lacks capacity, then the 3-year period only starts when they regain, if they regain capacity. There is discretion, but it's rarely used, so we wouldn't want to rely on that. So it's really important just to be aware of that, because obviously if you are aware someone has an accident, then they need to seek legal advice as quickly as possible. So the second bit of law, really, and it's fairly basic, I suppose, but we have to show, in order to win a case against an employer, we have to show that they are to blame. And what does that mean? How does that translate into law? And really, there's probably 4 tick boxes which apply. The first being, did the employer owe the employee a duty of occur? And in 99.9% of cases, the answer to that is yes. There are some exceptions which I won't go into, but it's taken as read, generally speaking, that box is ticked. So therefore, we then have to show that the employer breached that duty. Now, that could be in common law or statute, and I'll come on to that briefly. But what it really means is, did they fail to keep the employee reasonably safe? Or in other words, and as we would explain to a union member, did they expose them to a foreseeable risk of injury? Could they see that this would happen? And could it have been avoided? The third tick box is, did that failure cause the injury? And that seems straightforward sometimes, but it can be problematic, particularly in disease cases. And I'll give an example in a minute of that to illustrate that point. Was the injury not too remote? Was it not unexpected, I suppose? And the example that I sometimes give, and it might be a silly one, but I think it does show how this works, is that, let's say there's a hole in a factory floor, it's not fenced off, it's poorly lit, and someone falls down that hole and breaks their leg. Well, thinking about those 4 tick boxes, then yes, we've got the duty of care. Was there a breach? Of course there was a breach. There must be a foreseeable risk if there's a great big hole in the floor and it's not fenced off. And did the breach cause injury? Yes, this person fell down the hole and broke their leg. And was it too remote? No, it's an injury that you would expect in those circumstances. But let's consider exactly the same setup, except the person trips on their shoelace as they're walking towards the hole, falls over, breaks their leg, but doesn't fall down the hole. Well, it ticks the first 2 boxes again. The breach of duty is still there. It's not a reasonably safe place of work. There's a great big hole in the floor which isn't fenced off and it is poorly lit. But you can see that the third point, we don't get that. The breach didn't cause the injury. So it's a really important point that we have to consider in these cases. And a more realistic example, I think, is that we will represent people who work in hospitals, say, on psychiatric wards, for example, and maybe the protocol is that there has to be 3 people on duty. And on this day, there was only 2 people, for whatever reason, and they walk onto the ward and they are attacked by a patient and their nose is broken. Well, yes, there's a breach because there's a very good reason for having 3 people on duty, and there was only 2. But did that breach cause the injury? Probably not, because this was an attack that happened as soon as they come onto the ward. It was sudden. What difference would it have made if a third person had been on duty? And so again, that's something that we have to consider in those types of cases. And I mentioned common law and statutes.
Phil, 1 second. Before we start on
Yeah,
common law versus statutory law, we've just had a question that I think we should
yeah.
answer now before we move on. If you just flick back 1 slide, one viewer has asked, can you explain what you mean by the injury was not too remote, please?
So if and it's more of a, I suppose it's more of a technical issue, and it rarely comes up. But let's use that example where we fall over and we develop a heart murmur or something like that. And that perhaps might be an injury that is too remote from the breach that caused the injury. And a lot of it will, and it sort of links in with the medical evidence, which I'll come on to. But it's never usually, in, I don't know, 99% of cases, it never comes up. But it's something that we do just need to sometimes bear in mind, and that example I've just given might sort of illustrate that. Okay.
Yeah, that's great. Thank you. Let's go on to the common law versus statutory law.
So common law and statutes, statutory law, the common law duties, and then this is developed from cases that have gone before and judgments that have been made. And so that's how the law develops, by setting these precedents. And the duties would include keeping somewhere reasonably safe, having a safe system of work, safe equipment, adequate training, for example. Whereas your statutory law would be the six pack. So the management of health and safety regulations, and breaches of and looking for breaches of those. So this is Parliament made law as opposed to judge made law. And we plead both. I mean, there are issues involving the Enterprise Act, where in all its wisdom, the Tory government effectively said that you can't rely on a breach of statutory law in order to prove a case in a personal injury claim. That hasn't had such as much of an impact as we thought it would, but that demonstrates or illustrates the two types of law that we deal with. And looking at the process again briefly, then the first thing that happens is that we would get initial instructions via the trade union, giving brief details of the injury and how it happened. And that case would then be allocated to the appropriate branch or team or lawyer, because you've got specialist teams dealing with different types of injuries. For example, if it's a catastrophic head or spinal injury, then we've got a catastrophic team who would deal with that. And there would be an initial meeting, often depending on the value of the claim, by telephone or Teams, and we'd take full details of what happened, and we'd try as much as we could to give the member our initial view on prospects and any difficulties that the case might have, and also the evidence that we need to obtain, and that would be confirmed in a written advice, and the advice would effectively be that we can either we can bring a claim or make a claim and investigate it, or there is no basis of a claim here, and we would close that case. Now, if we do make a claim, then we've got to consider what the defendant's response is, and our next steps will depend on that. And so a defendant can either, as you can see, admit liability, i.e. they say, yes, it's our fault, or they might admit liability with allegations of contributory negligence. Yes, it's our fault, but your client, your member, could have taken better care of their own safety. They might deny it completely, or they might ignore it. And the next steps depend on that. If the defendant admits liability and admits with contributory negligence, which we think that a judge is likely to find, then we will accept that admission, or advise the client to accept that admission, and we will then look to try and quantify the claim. If they deny it or ignore us, then what we have to do is we have to make a judgment call using our experience and expertise to consider the law and the evidence that we have, and whether there are reasonable prospects of winning that case, i.e. Are we more likely than not to win that case? And I say that is very much a judgment call, and you'll see later where you can come in, health and safety reps can come in to help get the evidence that we need, and the case can be settled at any point. There'll be a timetable laid down, and ultimately we'll prepare that case for trial in case the defendants don't settle it. That's the process. So what do we have to prove, and how do we do it? So as I've suggested, we have to be able to show and prove how that accident happened. Think about the example of the hole. It's really important to get all the details from the member. We have to be able to explain why we say the employer was to blame. Think about those 4 tick boxes. We have to be able to to show that our member was exposed to a foreseeable or avoidable risk of injury. And we need to be able to provide medical evidence to show the nature and extent of the injuries. And of course, we have to be able to show what losses were incurred. And again, we need evidence for all those things. So to evidence to prove how the accident happened, the best evidence, it's the member, it happened to them. And that is clearly the best evidence. But we need clear instructions. And it's great having an eyewitness to be able to confirm and support what the client says, or indeed, if it is a serious injury, or the client loses consciousness, for the eyewitness to say what happened. And again, as a health and safety rep, if the member comes and tells you what happened, well, that's valid evidence. That's really, and particularly if it was straight after the accident, and sometimes that is really important, that reporting of the accident to somebody else. The accident report is crucial, depending on the employer. So Datix, if it's the NHS. Judges love contemporaneous documents. They can't get enough of them. And an accident report completed 2 hours after an accident compared to an accident report completed 10 weeks after the accident, then a judge is going to place more weight on the former rather than the latter. Now, that's not to say that if someone doesn't complete an accident report straight away, they shouldn't do it, because the latter is definitely better than nothing, particularly if the circumstances are disputed at some point. RIDDOR report, then if the accident is reportable, then again, that's really useful information that you potentially may have or should have access to. And just a word of caution, really, and again, that's something that where you can come in, is that the member must check carefully before they sign an accident report, a statement, for example, that it is accurate and that it is correct, particularly if someone else has completed it for them. And I know that can sometimes be difficult for members because, they might be in shock, they're suffering from pain, but it's really, really important and something that's worth remembering as a health and safety rep as well. So thinking about the breach again, this foreseeability and this avoidability, if you like, then what's the best evidence that an accident might be foreseeable? It's happened before. That's like your platinum level of evidence in terms of foreseeability. There's been a near miss, so it nearly happened. It's equally good in my view. Maybe gold standard could be there's been complaints about this or requests for changes. And again, health and safety committee minutes, health and safety committees, a perfect forum for making these complaints, for example. The defendant might say, well, we considered this complaint and we didn't agree that anything needed to be changed. But it is sometimes difficult for defendants to wriggle out of that. Again, risk assessments that either identify the risk or are non-existent. But we have to say, we'd have to be able to prove that it would have identified the risk if it had been done. And training documents and SOPs, the standard operating procedures, either they don't exist, or if training is done, but it's custom and practice not to follow that training, then that's really important. So an example would be members should use a particular designated walkway through a factory, and they weren't when they were hit by a forklift truck. Well, if the supervisors don't use that walkway, if no one else uses it, and supervisors are aware that people don't use it, then we can use that custom and practice argument. So it's having that knowledge, as we'll come on to see in the next 5 minutes or so, that's really important. And again, post-accidents, if there has been a change to the system. Now, whilst that isn't the silver bullet, if you like, because they've always got the argument that, well, it was unforeseeable, it's still really, really helpful, because what it does do is go towards the accident being avoidable. The injuries I've mentioned very briefly, that we need medical evidence to support that, either from, depending on what the injury is, orthopedic, psychiatrist, and they'll provide a diagnosis. They'll say how long the symptoms are likely to last, and they will comment on causation, which is an important tick box. As we've seen, just flagging up very briefly, because I think it's useful, because it's one of the things that most lay people, and I include myself in that, as I'm not a medic, find it difficult to accept. 45-year-old person perhaps has a back injury, no previous symptoms, few back problems in the past, and the accident has a significant effect on them. They have really unpleasant symptoms, can't work for 2 years, for example, and their life is affected. But the expert then looks at some x-rays, sees that there are these degenerative changes, so natural wear and tear, and comes up with an opinion which says, in the absence of this accident, they would have had similar symptoms anyway within 6 to 12 months of the accident. That is a really difficult thing to get your head round if you have never come across this before and you're not a medic or a medico-legal expert, and it is difficult to accept. But unfortunately, we have to rely on these experts, and the reason there is this is because there is a range of opinion. One expert might say, well, that's 3 weeks worth of symptoms I can attribute. The other one might say that's a lifetime of it. And what experts have done over many, many years is provided a range that's a realistic range, but it's something that a member might come to you as a health and safety rep and say, well, what about this? And that's just to give you a bit of background, I suppose, in that respect. Briefly looking at the compensation that you can get, it's split into two. The principle is that personal injury litigation is there to put the injured person back in the position they were in prior to the accident, so shortly before the accident. Now it's split into two: general damages, which is the actual injury, if you like, the pain, suffering, loss of enjoyment of life, and we work that out through looking at previous cases that have gone to court, but also looking at a little book called, well, it's now on screen, the Judicial College Guidelines, which is a summary, really, I suppose, a condensation of all the different types of injuries, and it gives the ranges of awards, and that effectively is what the judges use. The special damages are the financial losses, so you can see the examples there that might be included, both past, and if it's a more serious injury, then future as well. And just really to quickly highlight the types of awards that we might get, or the levels of them, and feel free, I'll give just 5 seconds maybe for you to use the chat to guess what you think someone might deserve, I suppose, if they do get such an injury.
Yes,
So
go for it, everyone. We'll give you a few seconds on this. 1,000, 5,000, 1,500, 2,000.
oh, that's not bad. They're pretty good. So I mean, that's not bad at all, really, in terms of some of them
Very
are a
accurate.
little bit more generous than the JCG, which is unusual. So more serious. This would count as a catastrophic injury. So an awful injury where your arm is amputated completely at the shoulder. What are we talking there, do you think?
Okay, so we've got 250k, 12k, 50, 750k.
Well, I'm glad the 12k isn't a personal injury judge, because that's
1
very
million.
1 million. Well, absolutely, and
Yeah,
that's the point, I think, is that if
it's
you were to
going
lose
by
your
quite
arm,
fast. So
yeah,
I'm trying to read.
I
Yeah.
would have expected, I think, at least £1 million, I think.
Mhm.
You're looking at probably somewhere between 160 and £200,000, which is extraordinary, really. And then finally, the worst possible injury, I suppose, you could think of, where you are tetraplegic. You can't move either your upper or lower limbs, associated with a brain injury, often certainly a spinal cord injury. What do we think there? How many millions of pounds do you
So
think we'll
yeah,
get there?
in the millions, 5 million, 10 million, unlimited. One
Yeah,
person said,
yeah.
three. Yeah,
So
whoa.
that's less than £500,000. So you can see that the compensation scheme in the UK is really, really ungenerous. £500,000 for never being able to work again is supposed to put you back in the position you were in terms of your ability to enjoy life, and that is worth less than £500,000. The reality is that when you see these multi-million-pound cases, tens of millions of pounds, then the vast majority of that is to do with special damages. So in that tetraplegic case, for example, then what would be built into that would be the cost of future 24 hours a day care, accommodation claims, etc., etc. But you know, I said this before. Sometimes in the cases I've dealt with, you ask people, well, if someone had said to you, well, I'll give you a check for £2 million, but this is what you've got to go through. Well, no, thank you. But you can see that it's fairly minimal, really. Um, so how can you, as health and safety reps, prevent or at least reduce the risk of injury, um, or help the injured person get compensation if they do have an accident or develop a disease? Um, Firstly, I think it's always worth repeating the mantra of the TUC and hazards, amongst others, that unionised workplaces are safer workplaces, and there's numerous publications, studies to support that, and so you play a vital role in making sure that that continues. Um, and we're in the 50th year of and 50th anniversary of the Health and Safety at Work Act, and it's a really important piece of legislation from 1974, and along with the 1977 Safety Rep Act, confers the rights that you have as health and safety reps to appoint, well, for reps to be appointed to investigate, to make representations, carry out inspections, and form safety committees. So that really was the starting point, I suppose. And from a practical perspective, then what can you do to make things safer? Then make sure there is a health and safety committee, have health and safety meetings, make sure that notes and minutes are taken, and that issues are raised and dealt with, and that there is an accident book, or at least a reporting system in place, so that accidents, no matter how minor, are reported. And again, just bear in mind that for defendants or employers rather to have employers liability insurance, then they have to present these documents to their insurance company, and they're always mindful of their premiums. Similar with near misses, make sure if we can to have a formal system of recording these. Emails are great, they're automatically time and date stamped. Make sure that we make complaints and that we log the replies. Again, it's trying to make sure that employers take health and safety seriously, that they carry out risk assessments so that those risk of injuries are assessed, and importantly, tell new staff about your role, how important that role is, and more so how important it is to join a trade union. And if the employers aren't listening to you, then speak to the HSE. Contact the HSE. You can report an employer. I would recommend speaking to your union first, but certainly that is an option and something of last resort. So what happens finally if an accident does occur and someone is injured? Then how can you help? Then make sure that you do investigate that accident and take statements from the relevant people, from witnesses, take photographs, make sketch plans if appropriate. Think about CCTV. It's really important. A lot of places have CCTV now. Make sure that we ask the employer to keep the copy of that, because that sometimes they're deleted after however long, and by the time someone has come to a lawyer, then it might be too late. So it's really important to be aware of that. Get a copy of the accident report, but before that, make sure that the accident report is completed and is completed firstly, and secondly, the client's happy with what's contained in it. See if you can obtain the risk assessments. You're out there on the ground, and it's really, really useful. And even if the answer is no, we don't have any, great. And that's often, from a personal injury point of view, better than actually having one. Again, we've talked about the importance of previous accidents, near misses, and complaints. Then, if we've got documentary evidence of that, brilliant. But if there's other people who have nearly had an accident or have had accidents, then that sort of information is really, really crucial to us as lawyers. Remind people of the union legal scheme and the need to get legal advice as quickly as possible, and also advise the injured person of the ability to claim industrial injury disablement benefit. It's a really important benefit that doesn't depend on whether the employer was to blame or not, and should be applied for at the earliest opportunity, particularly if someone has a nasty injury. And it can be backdated, but not for a huge amount of time. So all this information all goes towards the evidence that we've talked about, and really it hopefully demonstrates how, if we work together, then we can increase the chances of an injured person getting compensation. We need to know, if a client comes to us, we need to know who the health and safety rep is. And so if you are aware of an injury, then please make sure that they have your contact details, because we do want to contact you, and we will contact you to get that information. We'll have that conversation with you, or have that email exchange. And we want to rely on your expertise and knowledge. You have that expertise and knowledge on the ground. We don't have that. And it's really, really crucial. We've won umpteen cases because of some information that we have from a health and safety rep, and I'll briefly just refer to one of those cases. We might need a witness statement from you at some point, and I talked a little bit about RTAs, road traffic accidents that happen outside of the work, and just be aware of those, because they can quite often be some of the most serious of accidents that union members have. But then that link between the union and the injured member is potentially weakened or broken, because they never come back to work. So if you are aware of that, then please make sure that you speak to that member, and make sure that you advise them to contact the union helpline, so that they can get some advice. And again, be wary of the fact that if they go to a high street firm of solicitors, then they might only get 75% of their compensation. And just to finish, these are the grim realities of inadequate health and safety provisions. Stephen Hunt was a firefighter aged 38 who I represented more than 10 years ago now. He died in a fire in Manchester, going into the building 7 hours after the fire started, despite there not having been anyone in the building to save or rescue for the last 6.5 hours. He left two teenage children, a mum and a stepdad. And the coroner found that his death was completely and utterly unavoidable, and there were numerous health and safety failings. The Fire Brigades Union health and safety reps in the region and their team and the officials just sprang into action and helped massively with the investigation. Without them, we wouldn't, I don't think, have obtained the decision that we made that was made from the coroner, with a prevention of future deaths report, and I don't think that we would have perhaps obtained the compensation for the family either. So it's really, really important that your role is really important in investigating accidents and obtaining compensation. And finally, and I don't apologise for the gruesomeness of this particular photo, this was a 55-year-old man who was made redundant but had to take a job in a non-unionised recycling plant. Otherwise, his benefits would have been stopped. And to cut a long story short, he was asked to chip away to try and clean these rollers that stripped cables one on top of each other using a long-handled screwdriver and the back of an axe. And perhaps not surprisingly, his hand and glove were dragged into the rollers, them only stopping because his head hit a stop button. There were no union reps. It wasn't unionized. That would never, ever have happened in a unionized workplace. And I'm sure you would agree with that. His fingers were stitched on as best as the medics could, but there was no investigation. There was no proper investigation. And we ended up at a 4-day trial because the defendants tried to argue that this was completely outside of what he should have been doing. Thankfully, we won that case despite a Daily Mail reading judge. But with a health and safety union rep, firstly, the accident wouldn't have happened. If by some outside chance it did, then we wouldn't have ended up at court. We would have settled that much sooner. So hopefully that does demonstrate your important role that you play. There's some resources there. As I say, phone the Union Legal Services number if someone has an accident. You can get more information from our website. Actually, you don't need the code.uk, I don't think now. And then feel free to email me. I might be daft saying that. I might be inundated, but I'm more than happy to deal with any queries. So I will unshare my screen in case there's time for any questions, Anna.
Yeah, there is time. Phil, thank you so much. It was so incredibly helpful and comprehensive about the process from a legal point of view, but I think also highlighting how important the union health and safety rep role is in the evidence gathering, looking at previous incidents, and also the preventative role, making sure it doesn't have preventing the accidents of the future, as you said. I don't know whether you saw someone in the chat said that they used to care for the family of the firefighter you mentioned, so they thanked you for representing him in that
Absolutely.
case. Yeah. So we do have time for some questions. We've had quite a lot, but I'm going to try and group them thematically and to ask you to talk kind of generally about that issue. So we've had a few people ask, what is the deal if someone is working from home, if they've been instructed to work from home? What happens then if they have an injury? Is it possible to make a claim?
It's an interesting one, isn't it? I suppose I think it would very much depend on what happened to them. So, for example, if you're working from home and you trip over something that you've left on the floor, then no, you're not going to win that one. If, however, you are office based, you're doing an office based type job, and you develop some musculoskeletal problems, then as long as you have raised that with your employer and they've failed to maybe carry out an assessment, then there may be the basis of a claim there. I mean, particularly towards the end of lockdown, say, where people still had to work from home, then certainly if people were complaining about any musculoskeletal problems and nothing was done, then that was something that we have looked at. I think an employer might say, well, don't work from home if there is an option. If it's only an option to work from home, you need to come back into the office. But if your job is entirely home based, say, then yeah, certainly that's something that we would look at.
That's great, Phil. Thank you. Right, we've had a lot of people ask about stress and mental health, and the questions here fall into two categories, really. Stress as a kind of longer running issue, work-related stress, but also a mental health situation that is caused by a one-off incident. So, for example, violence at work, especially if you maybe work in a dangerous situation and an attack from a customer or service user. What's the deal there?
Yeah, I mean, dealing with that, the second one, so the attack, say you're attacked at work and you develop a psychiatric injury, then there is no issue in claiming for that psychiatric injury as well as the physical injury, along with any financial losses, as long as the expert, the psychiatrist, can link the attack to the onset of the psychiatric symptoms. And again, that would be a good example where causation might be a little bit cloudy, particularly if someone's already suffering from any psychological or psychiatric symptoms such as depression or anxiety or something like that. Then that might muddy the waters a little bit. But there should be no issues in claiming for the psychiatric injury as a result of that attack. The first one, which is the sort of longer term stress related issues, that they are more difficult to bring successful claims, because the law has developed over the years, and it's fairly clear now that what you have to show is that you have to be able to prove that your employer should have realised that not only you would be injured in some way, but that you would develop or likely to develop a psychiatric injury as a result of what's happening at work, if it's overwork, for example. And the case of Walker is many years ago now. It's a Thompsons case, but effectively someone was overworked, working 70 hours a week, developed psychiatric symptoms, went off work, came back. Nothing changed. In fact, it got worse, and they complained about it again. Nothing happened. They went off again with psychiatric injuries, and they never went back. And the judge in that one said, "Well, the first absence and the first psychiatric injury was not foreseeable. The second one must have been because it had already happened." It's almost a bit like having a previous accident. So it's a higher bar in some respects, but you need to have a diagnosis of a psychiatric injury, and generally speaking, you need 2 absences.
That's really helpful, thank you. Okay, we've had a few questions about obtaining information, especially from the employer. What if an employer isn't always helpful or isn't forthcoming with the supplying of that information to a safety rep in these cases? Someone, I think, particularly mentioned the Datix system,
Oh yeah.
and maybe be able to get information from that, but not Datix, other systems. What if an employer isn't providing what they should be doing?
I mean, you're entitled to it. I mean, I would need to double check the specific provisions in the Health and Safety at Work Act. But you are entitled to that information as a health and safety rep. I'm trying to think, and I mean, it's a really good question actually, and that has come up before, and it might be worthwhile me just having more of a think about that, because I think there probably is a small piece of work to be done on providing some advice to reps, and perhaps almost even having some sort of template email or something like that to refer to. So well, let me have a think about that, and I can get back to you, Anna. And
Yeah,
if
great
we
stuff.
if we can do something along those lines, then we could do. And we've got there is a health and safety booklet that we can probably we can share. I'll double check whether there's anything in there already, but certainly that's something that I think we could probably
Yeah,
work on with the
that's a great
TUC, I would have
idea.
thought.
One of our viewers has said, your rights as in the Brown Book, the Safety Rep Safety Committee's
Yeah,
booklet. We'll share this with you. The information is in there that you can quote, but it'll be helpful if we can put a template together
yeah.
as well. Okay, let me look at some of the other questions we've got here. Okay, you mentioned a little bit about diseases, industrial diseases, but is there any, have you dealt with any cases around infections? Lots of people are thinking, I think specifically about COVID, but infections in general that may have been contracted at work.
Yeah. I mean, COVID has been very difficult, and we have looked at a number of potential cases, and the law that would have been applied or was applied to those cases means that they are quite difficult to win, partly because you have to be able to precisely show where the COVID infection was contracted. Unless you were isolating, then you wouldn't get over that bar. And then the law that was applicable was also not that that we had to show that if various measures had been taken, it would have reduced the risk. The applicable law was that if various prevention measures had been taken, then it would have removed the risk completely. It would have prevented this person from contracting COVID. And unfortunately, the experts that we used in certain circumstances found that was quite difficult to prove. Other infections might include, and we've run cases for people who work on infectious disease wards, for example. And again, we've been pretty successful in those cases whereby if a patient is suffering from an infectious disease and the appropriate PPE hasn't been provided to the member, then yeah, you can run that argument. So again, I think in those sorts of cases, it's very fact specific, but certainly there are the bases of claims in relation to those types of cases.
Thank you. There's a question that I'm going to answer that I think is obviously more relevant to me. We've been asked whether you'll receive evidence that you attended today's webinar. Yes, we will. We'll be sending out a TUC digital credential either later today or first thing tomorrow for those of you who tuned in live. So please don't worry about that. And I am also aware we've had a lot of questions today and we're not going to be able to answer all of them. So we're going to try and mop up some of these next week where we'll group them and maybe work with Phil to answer some more of those. So watch this space. We'll be in touch with you if you know about these questions. So please don't think we're ignoring you. I think we've got time for maybe two more, just briefly. So we've got someone who's asked about exposure to asbestos. And they say they might not have shown symptoms within the 3-year period that you mentioned. What's the deal here? Whether it's asbestos or something else that maybe has a long time before symptoms show? Is there a redress?
Yeah, no. I hate it when politicians say that's a really good question because it sounds really patronising, doesn't it? But that is a good question. So no, it's fine because if you think about the time limit for diseases, then it's 3 years from the date when you realised you were suffering from a condition that was work related. So if it's fine. You might have worked with asbestos for 25 years, and you might have retired 30 years ago, or but you didn't develop any symptoms until recently. And if you develop symptoms recently and then made that connection within the last 3 years, then unless there's some evidence that that maybe your symptoms started 10 years ago and you should have realised, then you should be fine. There won't be any difficulties in relation to showing that that's within the 3 years. So as long if your symptoms start now, then effectively you've got 3 years from now to bring a claim. And even if they started before now, there are arguments around that. And as I say, I said that discretion is rarely used. Those sorts of cases it probably, well, there's an argument that there's a greater chance of using discretion. A similar sort of case might be sort of historic child abuse cases, but yeah, it doesn't. If you issue court proceedings within 3 years of the symptoms starting, then you'll certainly be within time. So it doesn't tend to be a huge problem with asbestos cases. It's something that we do need to consider, but yeah.
Thank you, Phil. And the final question, I'm going to ask you to end on like a practical note. around best practice for witness statements from well, the witnesses. If the rep wasn't there as the witness, what are maybe the top 3 or 4 things that they should be asking from the colleague who was?
The main thing really is a really clear description of what happened. That just and again, it applies to lawyers as well, because if, and I say this to people that were training within Thompsons, if you yourself don't understand how an accident happened, how can we explain that? So how can you explain that to a judge? So that, particularly in sort of machinery cases, sometimes my hand caught in the machine. Well, why did it catch in the machine? So I think a clear description that you understand yourself about the mechanism of the accident is really, really important. And also, if the client can, or the member can provide any information regarding, I don't know, training or something like that they may that they haven't had, for example, then that's really helpful. But I think if, as long as there's a clear description, then that probably is the most important thing about taking a witness statement, and also to take it as soon as you can after the accident, so that it's fresh in someone's mind. So yeah.
Thank you, Phil. That has been fantastic. We're getting lots of thank yous in the chat panel saying that they learned so much from your presentation. So really helpful. And as I said, we'll have a method of mopping up the questions so that we can try and answer as many of them as possible. Before
Brilliant.
we go, I just want to tell you, our audience, that we have what has become now our annual event for workplace reps. It's on the 15th of October this year. And one of Phil's colleagues will be coming to give you an update on everything that's been going on with employment law in the past year, and maybe some ideas about what's on the horizon, what's coming up. And that is always really popular, incredibly helpful, and everyone who attends learns loads. We will make sure that the link is sent out to you all so that you can register if you like. And I look forward to meeting loads of you at that event. And finding out what's going on in your workplaces. We have another webinar in a few weeks. We look forward to seeing you at that soon. But bye-bye for now.
Thanks. Nice to see everyone.